Welcome to LexTalks Legal Topics, simplified your companion for exploring the fascinating world of law. Today, we're diving deep into something you'll encounter throughout your legal careers as law students in India.
Article 21 of the Indian Constitution.
Exactly. It's short, it seems simple,
Yeah.
but trust me, it's a lot deeper than it looks.
Oh, it really is. It's like the Swiss Army knife of the Indian Constitution. It's not just about staying alive. It's about having the tools to live a life with dignity, opportunity, and basic freedoms.
Okay, so imagine this. You're a lawyer in India, and your client's passport has been confiscated, or they've been detained or denied, something crucial to living a decent life.
Article 21 is often your starting point.
For sure.
Yeah.
It states, no person shall be deprived of his life or personal liberty except according to a procedure established by law.
Yeah,
But unpacking those few words leads us down a rabbit hole doing
Absolutely.
interpretation and debate.
absolutely. One of the first things law students grapple with
Yeah?
is what exactly constitutes a valid procedure established by law. Does ANY law, as long as it's passed correctly, automatically satisfy Article 21?
Well, some lecture notes I came across lay out 3 requirements a law needs to meet under Article 21.
Okay.
First, there has to be an actual law created by the appropriate authority.
Makes sense.
Second, that law must define a procedure for depriving someone of life or personal liberty.
Right.
And thirdly, the state has to actually follow that procedure. Seems pretty straightforward, right?
It does, but the interpretation of Article 21 has evolved significantly over time.
Oh, wow.
To appreciate that evolution, we need to look at landmark cases.
Okay.
Take the Maneka Gandhi case, for example. The Supreme Court's decision in that case completely changed how we understand Article 21.
Hold on. So before this case, the government could take away your passport without a second thought.
Well, yeah, pretty much.
What was Maneka Gandhi's argument against that?
Maneka Gandhi argued that the government's order to confiscate her passport was a violation of Article 21 because it wasn't just about the process,
Okay.
but whether the law itself was just fair and reasonable.
And the court agreed with her.
They did.
This was a massive shift from earlier interpretations like the A.K. Gopalan case in 1950,
Right.
where the focus was solely on whether the correct procedure had been followed.
Exactly. Back then, the court basically said, look, if there's a valid law and the state followed the right steps, we're not going to question whether the law itself is fair or not.
Wow.
The Maneka Gandhi judgment essentially said, hold on, the procedure established by law cannot be arbitrary or unjust. It has to meet certain standards of fairness and reasonableness.
So how did this shift happen? Why did the Supreme Court change its stance so dramatically? Did something happen between the Gopalan case and the Maneka Gandhi case?
Well, one factor was the historical context. Remember,
Yeah.
the Maneka Gandhi case took place after the emergency, a period when fundamental rights were severely curtailed.
Right.
The court was acutely aware of the dangers of unchecked state power.
That makes sense.
Yeah.
The court was essentially saying, we need to be more vigilant in protecting individual rights.
Yeah.
And that includes ensuring laws themselves are fair, not just the procedures they outline. This has a huge impact on how lawyers today argue cases related to Article 21, right?
Absolutely.
It's not enough to simply demonstrate procedural compliance anymore.
No, you have to delve into the substance of the law and argue its fairness.
Right.
But this evolution of Article 21's interpretation gets even more interesting when you consider the ADM Jabalpur case,
Okay.
which also happened during the emergency.
Wait, so during the emergency, the courts were basically upholding the government's restrictions on fundamental rights?
Yeah, essentially.
That's terrifying. What happened in the ADM Jabalpur case?
The court, in a majority decision, essentially upheld the government's restrictions on fundamental rights during the emergency, including those under Article 21.
Oh, wow.
It's a bit of dark chapter in Indian legal history.
So even with Article 21 in place, individual rights were still incredibly fragile during the emergency.
Yes. However, there was a powerful dissenting voice in that case, Justice H.R. Khanna. His dissent became incredibly influential later on, helping to shape the court's more expansive approach to Article 21 in subsequent cases.
It's fascinating how one dissenting opinion can have such a profound impact on legal interpretation down the line.
It really is.
So from the Gopalan case to the Maneka Gandhi case and the dissenting opinion of the Jabalpur case, it's clear that the interpretation of Article 21 hasn't been static. It's been shaped by historical events, judicial interpretations,
Right.
and even dissenting voices. But how has this impacted Article 21 today?
Well, it's evolved to include a wide array of rights beyond the literal meaning of life and personal liberty. What's remarkable is that Article 21 isn't just about preventing the state from taking your life or locking you up. It's evolved to include rights essential for living a dignified and meaningful life.
So Article 21 is about more than just surviving. It's about truly living.
Exactly. It's about the right to a clean environment, to food, to a speedy trial, to livelihood, even the right to sleep undisturbed. This expansion of Article 21 was really highlighted in the Olga Tellis case, where the court recognized that evicting pavement dwellers without providing alternative accommodation would violate their right to life, because the right to life includes the right to earn a living.
So the right to livelihood is also protected under Article 21. Wow, that's huge. What other rights are included?
Well, in the Hussein R. Khatun case, the court recognized the right to a speedy trial as essential to the right to life and personal liberty under Article 21.
So even something like a delayed trial can be considered a violation of Article 21.
Yes, the court forced the government to take action and address the horrific conditions and delays faced by these prisoners. It's a case that really tugs at your heartstrings. Imagine being stuck in prison, presumed innocent, but with no idea when you'll ever get your day in court.
That would be awful.
Yeah.
It makes you realize that the right to a speedy trial is about so much more than just efficiency. It's about basic human dignity.
Exactly. And then there's the Vishaka v. State of Rajasthan case, which dealt with sexual harassment at the workplace.
So before this case, there were literally no legal protections against sexual harassment at work. That's insane. How did they even argue that using Article 21?
The court recognized the lack of specific legislation and drew on Article 21's guarantee of a dignified life to lay down guidelines for preventing sexual harassment.
These were the Vishaka guidelines, right?
Mhm.
I remember learning about those. They became the de facto law on sexual harassment until formal legislation was finally enacted.
Precisely. It's a prime example of how the court can step in, even in the absence of legislation, to protect fundamental rights using Article 21 as a foundation. And this brings us to a question that often comes up when studying Article 21.
Okay.
Why does the Indian Constitution use procedure established by law while the U.S. uses due process of law?
Yeah, what's the difference? Why did India choose that wording?
One key reason lies in the historical context. India, at the time of drafting its constitution, was wary of giving the judiciary too much power. They'd seen how the U.S. Supreme Court, using the due process of law clause, had struck down several pieces of social welfare legislation in the early 20th century. They opted for procedure established by law, which they believed would give more deference to the legislature.
So they were worried about unelected judges potentially obstructing the will of the democratically elected legislature.
Exactly.
But hasn't the Indian judiciary, especially after the emergency, read substantive due process into Article 21 anyway?
That's right. They've essentially said, yes, the legislature makes the laws, but those laws cannot be arbitrary or unjust. They must be fair, reasonable, and respect the dignity of the individual.
So did the Indian framers' fear of judicial overreach based on the U.S. experience actually come true?
It's a fascinating question. It seems like the Indian experience with procedure established by law has been quite different from what the framers might have envisioned.
And speaking of rights that aren't explicitly mentioned in the Constitution, what about the right to privacy? I know that wasn't originally in the Indian Constitution.
You're right, but that doesn't mean it doesn't exist in India. In a landmark 2017 judgment, the Supreme Court declared that the right to privacy is a fundamental right, and guess what?
They derive it from Article 21.
Exactly. The 9-judge bench in the Puttaswamy case held that privacy is intrinsic to life and liberty and therefore falls under the protection of Article 21.
This judgment was a game changer. It acknowledged that privacy is essential for individual autonomy, dignity, and freedom. And it's had a ripple effect on various aspects of law, from data protection to surveillance to even personal choices like whom you marry or your sexual orientation.
It has. And this brings us to another very complex aspect of Article 21, the right to die with dignity. The question of whether the right to life also encompasses the right to die has been a subject of intense legal and ethical debate in India.
So is there a right to die in India?
Well, in the case of John Carvey's state of Punjab, the court held that the right to life doesn't include the right to die. However, there's a lot of nuance here. The court has recognized the concept of passive euthanasia in certain circumstances.
So passive euthanasia is allowed, but not active euthanasia. What's the difference?
Passive euthanasia is allowing someone to die by withholding or withdrawing life-prolonging treatment. The landmark judgment in this regard is Common Cause v. Union of India, which allowed for living wills where individuals can express their wishes regarding medical treatment in advance. Active euthanasia, on the other hand, is taking a specific action to end someone's life, like administering a lethal injection. That is not legal in India.
Okay, that makes sense. So while active euthanasia remains illegal in India, the court has taken steps to recognize the right to die with dignity, at least in the context of passive euthanasia.
Yes, and this evolving jurisprudence reflects the complexity of these issues as well as the court's willingness to engage with them even when there's no clear-cut answer.
Now, one thing that might surprise people is the connection between Article 21 and environmental protection. How can a provision focused on individual rights be used to protect the environment?
Well, it's become increasingly clear over the years that environmental degradation directly impacts our right to a healthy and dignified life. The Supreme Court, through its creative interpretation of Article 21, has been at the forefront of environmental jurisprudence in India.
So they've essentially said that environmental rights are also human rights.
Exactly. Landmark cases like the Rural Litigation and Entitlement Kendra v. State of UP, the Dehradun Valley litigation, and MC Mehta v. Union of India, which dealt with pollution and mining in the Aravalli Hills, have established the right to a clean environment as an integral part of Article 21. The court has also taken on issues like noise pollution, emphasizing that excessive noise levels can infringe upon our right to a peaceful and healthy life.
This is also interesting. It really highlights the interconnectedness of various rights. Environmental rights are not just about protecting nature, they are about protecting human dignity and well-being.
They are. And this approach has had a tangible impact on policy and lawmaking in India, pushing the government to take environmental concerns more seriously.
So for our law student listeners, remember that Article 21 is not just about preventing arbitrary arrest or detention. It's a powerful tool for addressing a wide range of social justice issues, from environmental protection to ensuring a dignified life for all.
Absolutely. Let's delve into another critical aspect of Article 21 that has a huge impact on the administration of justice: the right to a fair trial.
Okay, so we know that a fair trial is a cornerstone of any democratic society. But what does it actually mean in the context of Article 21?
A fair trial encompasses a bunch of rights and principles designed to ensure that justice is delivered impartially and effectively. It's not just about having a trial, it's about ensuring that the trial itself is conducted in a manner that upholds the principles of fairness and due process.
So what are some of these rights and principles?
Well, some key elements include the right to be informed of the charges against you, the right to legal representation, the right to a public hearing, the right to examine witnesses, and the right to appeal. These rights are crucial for protecting individuals from arbitrary or unjust convictions.
And how does Article 21 play into this?
Article 21 acts as a safeguard, ensuring that any procedure that could deprive someone of their liberty must adhere to these principles of fairness. And one specific aspect of a fair trial that's garnered a lot of attention in India is the right to a speedy trial.
Right, the idea that justice delayed is justice denied. Didn't we talk about that earlier with the Hussain Khatun case?
We did. Prolonged trials can have devastating consequences for the accused, even if they're ultimately found innocent. Imagine being stuck in jail for years, awaiting trial with your life essentially on hold.
That's a huge violation of personal liberty and dignity. But what about the flip side of that? What about ensuring that trials are not just speedy, but also fair? Can we sacrifice due process for the sake of expediency?
That's a valid concern, and it highlights the delicate balancing act involved in upholding both the right to a speedy trial and the right to a fair trial.
So it's more complicated than just demanding that every trial be as quick as possible.
It is. There might be cases where ensuring a thorough and fair investigation takes time. In such cases, the courts have to weigh the competing interests and ensure that any delays are justified and don't unduly prejudice the accused.
So how do they determine what's reasonable?
The courts have developed various criteria for determining reasonableness, taking into account factors like the complexity of the case, the conduct of the parties, and the availability of resources.
Okay, so there's no easy answer.
Well,
But the key takeaway is that both speedy trial and fair trial are essential components of a just legal system, and Article 21 serves as a crucial safeguard for both. Now, what about the death penalty? I know that's a controversial issue in India.
it is India, unlike many other countries, still retains capital punishment for certain offenses. There are strong arguments both for and against it.
On one hand, I can see the argument that some crimes are so horrific that they deserve the ultimate punishment. But on the other hand, I can also see how capital punishment raises serious ethical concerns about the state taking a life, especially with the possibility of wrongful convictions.
Exactly, and the debate on the death penalty continues. But the Supreme Court has repeatedly held that the death penalty can only be imposed in the rarest of rare cases.
So how does Article 21 factor into this?
The Supreme Court has also held that even in death penalty cases, the procedure must be fair, just, and reasonable. All legal avenues for appeal and clemency must be exhausted before the sentence can be carried out.
It sounds like they're trying to ensure that even when facing the death penalty, a person still has the right to a fair and just process.
Yes, and there's also a growing concern about the mental anguish and prolonged suffering experienced by death row convicts due to delays in execution.
So even if someone is sentenced to death, they still have rights under Article 21.
They do. The court has recognized that undue delay in carrying out a death sentence can amount to torture and a violation of Article 21. It's led to calls for abolishing the death penalty altogether, or at least commuting death sentences to life imprisonment in cases of prolonged delay.
It really emphasizes that Article 21 protects even those convicted of serious crimes.
It does. Another area where Article 21 has been invoked is in cases of police atrocities and custodial deaths.
It's no secret that police brutality and abuse of power are a problem in India. We've seen far too many instances of arbitrary arrests, torture in custody, and even extrajudicial killings. How does Article 21 come into play in these situations?
Article 21, with its guarantee of the right to life and personal liberty, has been a powerful tool for seeking justice in such cases. The court has repeatedly condemned police excesses and emphasized the importance of upholding the rule of law.
So what are some of the specific things the courts have done to address police brutality?
Landmark judgments like D.K. Basu v. State of West Bengal have laid down specific guidelines for police conduct during arrest and detention.
What kind of guidelines?
These guidelines include informing the arrestee of their rights, allowing them access to legal representation, and documenting the entire process to ensure transparency. The court has also awarded compensation to victims of police brutality, recognizing the violation of their fundamental rights under Article 21.
Wow, it sounds like they're taking concrete steps to hold law enforcement accountable.
They are. The courts have sent a strong message that no one, not even law enforcement officials, is above the law. Everyone is entitled to the protection of their life and liberty.
Now, shifting gears a bit, I want to talk about something that's incredibly important, especially for women in India. The right to live free from violence and harassment.
Violence against women, whether it's domestic violence, sexual assault, or harassment, is a pervasive problem in India, and for far too long it's been treated as a private matter.
Something that people just didn't talk about. But how has the legal system started to address this?
The courts have recognized that violence and harassment have a devastating impact on women's lives, their dignity, and their ability to exercise their fundamental rights. And they've used Article 21 as a powerful tool for addressing this issue.
So they're finally recognizing that this is a serious problem that needs to be addressed.
Yes. The Vishaka case, for example, was a landmark judgment in this regard. The court laid down guidelines for preventing sexual harassment at the workplace.
These guidelines, known as the Vishaka Guidelines, were a game changer. They recognized that women have a right to a safe working environment free from harassment, and that employers have a responsibility to create that environment.
Exactly. The Vishaka Guidelines have since been codified into law through the Sexual Harassment of Women at Workplace, Prevention, Prohibition, and Redressal Act 2013.
It's a testament to the power of judicial activism and how Article 21 can be used to push for social change, even in the absence of specific legislation.
It is. And another area where Article 21 has played a crucial role is in addressing domestic violence. The Protection of Women from Domestic Violence Act 2005 draws heavily on the principles enshrined in Article 21.
So this act recognizes that domestic violence is a violation of women's fundamental rights under Article 21.
It does. It recognizes that domestic violence is a violation of women's right to life and liberty, their right to live with dignity, and their right to a safe and secure home environment.
And what about remedies for victims of domestic violence?
The Act provides a wide range of remedies for victims of domestic violence, including protection orders, financial assistance, and counseling.
That's incredible. It's been a significant step forward in addressing this often hidden but pervasive form of violence. And it demonstrates how Article 21 can be used to protect not just physical safety, but also emotional and psychological well-being.
It does, and that brings us to a really important point about Article 21.
What's that?
It's not just a static provision, it's a dynamic concept that's constantly evolving through judicial interpretation.
So it's not just about what the words on the page say, it's about how those words are being interpreted and applied in the real world.
Exactly. And the Supreme Court has expanded the scope of Article 21 to encompass a wide range of rights beyond the literal meaning of life and personal liberty.
We've seen that throughout our discussion today.
We have. These rights include the right to livelihood, the right to a clean environment, the right to education, the right to privacy, the right to a fair trial, and many more. Article 21 has become a powerful tool for social change, allowing the courts to address issues like police brutality, violence against women, and environmental degradation.
It's a testament to the creativity and commitment of the Indian judiciary in using the Constitution to protect the rights and dignity of all citizens.
It is. And that brings us to another important point about Article 21.
Okay, what's that?
It's not just about the right to life and personal liberty as we traditionally understand them. It goes much deeper than that.
So it's not just about physical survival or freedom from imprisonment.
Right. It's about ensuring a life of dignity and meaning a life where individuals have the opportunity to flourish and realize their full potential.
Okay, so how has the court interpreted Article 21 to encompass these broader aspects of human existence?
The courts have taken a very holistic view. They've recognized that certain rights, even if not explicitly mentioned in the Constitution, are essential for a life worth living and are therefore implicit in Article 21's guarantee of life and personal liberty.
Can you give us some examples of these implied rights?
Well, take the right to education, for instance. It's not specifically mentioned in Article 21, but in the case of Unikrishnan JPV, state of Andhra Pradesh, the Supreme Court held that the right to education until the age of 14 is a fundamental right flowing from the right to life.
So the court said that without education, a person can't truly live a full and meaningful life.
Precisely. They recognize that education is essential for individual development, for social progress, for informed decision-making, and for participating fully in a democratic society.
That makes a lot of sense. So what other rights have been read into Article 21?
The right to health is another example. In a series of cases, the court has held that the right to health is integral to the right to life, and that the state has an obligation to provide essential health care services.
So access to health care isn't just a matter of policy. It's a fundamental right under Article 21.
It is. The courts have directed the government to take steps to improve healthcare infrastructure, to ensure the availability of essential drugs, and to provide medical care to the poor and marginalized.
It's amazing how much Article 21 has expanded to cover so many aspects of human life. It's not just a legal provision, it's a reflection of our values as a society, our commitment to human dignity and well-being.
Exactly. And it's this commitment that has driven the courts to use Article 21 to address a wide range of social issues, from environmental protection to the rights of prisoners to the rights of children.
It's really inspiring to see how this one article has been such a powerful force for good.
It is. And it's a reminder that law is not just about rules and regulations. It's about justice, fairness, and ensuring a life of dignity for all.
Well said. So as we wrap up our deep dive into Article 21, what are some final thoughts for our listeners?
I'd say remember that the journey of Article 21 is far from over. Its interpretation continues to evolve as new challenges and new questions emerge.
And as future lawyers, you have a crucial role to play in shaping that evolution.
You do. Your understanding of Article 21, its history, its nuances, its potential, will be crucial in advocating for your clients, in upholding the rights of the vulnerable, and in ensuring that the promise of a just and equitable society is fulfilled.
That's a powerful message to end on. Thank you for joining us on this deep dive into Article 21 of the Indian Constitution. It's been an enlightening journey.
It has.
Thank you for listening to LexTalks. Follow, subscribe, and stay notified to never miss an episode.